Johnathan Rees. I'm a corporate lawyer based in London now with a firm called Joelson Wilson, a commercial law firm. And what do I do? I'm advising corporates on mergers and acquisitions, private equity transactions and commercial agreements of various hue. Based in a quite nice part of town, actually, in Portland Place in London. Got views from the front door up to Regent's Park at one end, and if you turn left, you've got views down to the Langham Hotel and Broadcasting House on Oxford Street. And I said to my secretary last night, I panicked yesterday. I mean, the presentations have been fantastic, and the slideshows have been wonderful, and I'm responsible for what follows. But I did ask her yesterday, I said, you know, this was me. This is a picture of me and taken from about 1976 on this slide. And I said, I've got to jazz this up. I said, send me a picture. Send me that slide, you know, which covers the aspect, the view from the front door. And, well, you know, it's a good front door, but that's not what I had in mind. Anyway. So Claire and David have asked me to talk to you this morning about the legal aspects of setting up in business, and I'm conscious that time is tight, and it's a fairly broad subject, so apologies if this is more of a thumbnail guide than anything else, but here's the ground I'm hoping to cover. I'm going to start with an analysis, brief analysis of the different business structures that are out there for anybody looking to start up in business. Then I'm going to talk about the nature of the private company, because that's what I know about. And more importantly, your role vis-a-vis the company, the roles and responsibilities you've got. I'm going to touch on the commercial issues involved in starting up a business and the operational aspects. Don't worry, that'll be a canter through that bit. And I'm going to close with some words of wisdom and a brief story of a successful startup, which my firm were involved in. So, without any further ado, the first thing to say to anybody, any of you guys, anybody starting up in business is congratulations. It's probably one of the bravest and most exciting decisions you'll ever take. But the next thing, as a lawyer, you say is why. Not to rain on your parade, but to better understand really is what you're about, what you're trying to achieve, because your objectives and aspirations will influence the form of business structure that you should be adopting. Now, this is my least favourite slide, and if you're interested, this is Blue Accent 1. This took me ages to prepare, but this is... So what we've got down the left, these are the different structures, and they break broadly into two. We've got incorporated, and by the way, if you can't see the slide, you're not missing anything, okay? But we've got incorporated at the top and unincorporated at the bottom. Now, the private company and the limited liability partnership, or LLP, they're the incorporated structures. And they benefit from limited liability, and that's key. And for anybody that walks through my door or our door in terms of a startup, this is the advice that we give them. You know, private company is probably the most popular corporate vehicle anyway. The downside to that limited liability, that comfort that if it all goes pear-shaped, all you lose is the investment in the business, you don't lose the farm. The downside is the publicity that goes with that. In other words, filing of accounts and the compliance, there's annual returns to file and so on, which is a pain, but frankly, I think worth the trade-off. LLPs, well, less relevant to this particular audience, I think, but what they benefit from as well is what's called tax transparency. So in other words, the members of the LLP are assessed a tax rather than the overall corporate structure. When you're a company, you've got this dual tax structure. You've got the company suffering tax at the corporate level, and then when the shareholders get the tax out, they pay tax on the dividends. So not the most efficient corporate structures, but I say they do benefit from limited liability. Sole trader partnership, well, what are we talking about? Sole trader, if you're sitting there with your laptop and you start business right now, then that makes you a sole trader. Ditto, you set up with a guy sitting next to you, that puts you two in partnership. The bottom line is the two of you, the one of you, you're personally liable for everything, all the debts and obligations of your business. Not a good place to be, but funnily enough, as we're about to see, the most popular form of business structure in the UK. And I've mentioned finance because actually banks are not too keen on partnerships and sole traders. not necessarily because of their net worth, but they're complicated structures to deal with in terms of taking security. So as I say, I'm focusing this morning, they're the structures, but I'm focusing largely on private companies. And I thought, as I said, apologies at the outset, really. I wasn't sure how to pitch this, in that I'm sure there are certain people in the audience who maybe have their own business and are company directors, are shareholders, and there are others here who are just starting out. So this might be teaching some of you to suck eggs. But anyway, I thought I'd just explain briefly the nature of the private company. This is a fundamental corporate legal concept, this theory of separate legal personality. And what this means is that the company is an independent person from its promoters, from its directors and shareholders. In other words, the company is a person. It can own property, it can sue, it can be sued, it can fire, it can hire. And that is significant for the entrepreneur, because he has, you have, she has different hats when you're a director or an employee or shareholder of that company. And you may be a creditor, you may put loans into the business, and those different contexts give you different responsibilities and obligations. And with those obligations come responsibilities, come duties, and the problem for many entrepreneurs, and this is very understandable, a lot of owner-managers in our experience tend to see the company as them, and they are the company. And it's that blurring of lines, which is very understandable, but it's in that blurring of lines and identities where most mistakes and exposure arises. And the bottom line, and it's tedious, but for anybody starting a business or through a company, familiarizing yourself with the director's duties is key. Because, and I'm sorry, I mean, it's inevitable doing what I do for a living that I talk about failure and wrongdoing and everything going pear-shaped, but that's the essence of the job for us. But the bottom line is we're out there to protect you. And as long as directors, you've done the right thing, that if it all goes wrong, the bottom line is for us that there's nobody coming after you personally. That's the whole essence of setting up a company. It's about doing the right thing and protecting yourself ultimately if it all goes pear-shaped. And most of the scandals that we've seen on the UK stage and the global stage the last 10, 15 years have had breaches of directors' duties at their heart. So, consequences not to be underestimated. How am I doing? This is a bit more interesting. So now what I thought I'd touch on is the commercial issue. So the context here is you're walking into a lawyer's office and you're sitting down and you say, oh, I've got this business concept. I've decided the road I'm going down is a company. I don't want to be a partnership. You've bored me rigid with your partnership stuff. I don't want to lose the house. I'm decided I'm going to be a company. What are the issues? What do I need to think about in setting up that company? So breaking these down, the headings really for an entrepreneur are ownership, management, and exit. Ownership, well, the ownership of the company lies with the shareholders. And that is a function of the fact that all the benefits, all the powers in relation to a company lie in its share capital. So it's the shareholders ultimately hold all the power. Voting, well, so as a shareholder, what have you got? The basic rights as a shareholder are the right to vote and the right to some sort of income, dividend. Voting is normally fairly straightforward. It's one vote per share, but you can adapt that because, as I'm about to touch on, a lot of businesses like to expand the equity base, spread the shares, get employees involved. Staff incentivization is really key at the moment, and aligning shareholders and management's interests. And if you do that, one of the things that owners tend to be reluctant about is seeding equity, getting somebody else involved in their business and cluttering the decision-making process. So the voting of shares, the rights attaching to shares can be tweaked any way you like, adapted to suit your business. And so, commonly you'll issue shares to the employees which are non-voting, and they won't vest, if you like, until the business hits a particular level of profits or there's an exit at a particular level. But the bottom line is that the employees have got some shares, they've got a stake in the business, so you're aligning their interests without cluttering your ability to run it in the interim. Income, well, there are two ways of extracting income from a business. There's a salary as a director and employee, and there are dividends, and there are tax aspects to each. And you'll be relieved to hear I'm not going to touch on tax at all this morning, but you've got that flexibility with a company in terms of how you extract the income. The there are two ways of becoming a shareholder. You can either have a share issued to you by the company, a new share, so money goes into the company's pot, or alternatively, you can buy an existing share from a shareholder, so the money goes into their pocket. Most private companies have fairly strict rules about the way shares are issued and sold. So the principle being they like to keep it in the family, so to speak. In other words, they'll have if you want to sell a share, you'll have to offer it to the existing shareholders first and so on. And that's the advice most lawyers will give their private company clients, because they do like this ability to retain some control over who their co-owners are. Tax reliefs, I'm not going to say a great deal on this, other than the fact that for startups looking for money, equity, there are lots of incentives, reliefs out there for investors, and it's worthwhile. I guess the moral of the message for you this morning is if you are looking to raise money for a startup is to get a tax advisor, unfortunately, on board fairly quickly, because the way you time the issue of shares and the way you structure your board and everything else can have an adverse impact or affect the ability for people to obtain relief. Management. So we talked about ownership. That's at one level. We've got the ownership of the business there. So how is it run? The business is the management of the business is delegated to the directors, the board of directors. Now, in most businesses that we deal with, the directors and shareholders are one and the same. Own and manage businesses. That's the concept. But occasionally, where you may have taken an investor on board, or there may be, it's a joint venture between 3 or 4 of you, you may have several directors. And that's where life becomes slightly complicated, because basically the way the law works, any director, any single director has got the authority to commit your company to any contract he wants. Somebody dealing with a business doesn't have to question it. As long as he's a director, on the face of it, he's got the authority to commit the business to that liability. So when you're starting up together, it's not necessarily a question of trust, but sometimes the directors, as I said, if there's 3 or 4 of you, decide, okay, well, let's identify a list of things which we all agree can't happen unless either we've discussed these at a proper board meeting. That's a board meeting, by the way, that little thing there. Or alternatively, we've each got a veto over these things. So I don't want you sacking staff. I don't want you going out and buying a car unless we've discussed this at board level. And those issues are then enshrined in a shareholders agreement. And that's, unfortunately, where people like me come in. And we draw up these things for you, hopefully keep it simple. But again, all it's about is putting you as directors, as promoters of your business, in a position where you can sleep at night. Vetoes, well, that's exactly what I'm talking about. If you get an investor will come along and he will, want to be that guy. He'll be the guy in blue. And he'll be listing in 2 or 3 pages of A4 a whole raft of things that can't happen without his consent. And that's a subject all in itself, actually, taking on private equity. That's my world. And that's just a brief comment. A lot of businesses are, as I said earlier, reluctant to concede or cede private equity. And in my experience, actually, if you get the right investor on board with the right connections and the right experience, then they bring a lot more to the party than just cash. And that's not a plug for private equity per se, but it's, I think, a sort of widening of people's minds towards fundraising is no bad thing. So ownership, management, and exit. This is the really good bit for you. This is when you sell your business. So if you've divested the share capital amongst staff, or you've got an investor, the one thing that everybody wants to achieve, you, the manager, having worked your business into a position after 5 or 6 years where it's worth whatever, you get an offer for the business that you want to accept, and all of a sudden you've got 20% of your share capital tied up in this employee benefit trust. So the issue for you, and this is what we were talking about earlier about retaining control, is to make sure that you can force the other shareholders to accept that offer. And again, that's all stuff that we put together in the articles or a shareholders agreement right at the beginning of the process. So although you're conceding equity up front and you've got staff involved, you've got that ability to control the way the business exits. So you've started the business. What are the next steps? I will keep this very brief. I'm not going to talk about brand protection because I think that's a subject of a separate talk. Suffice to say that if there's any valuable IPR, intellectual property in your business, I know there are various views yesterday which were fine. I mean, the idea for me as a lawyer of giving anything away is just anathema. And I'm sure it's illegal in England. I don't know about Wales, but it's the first thing you should do, register it. Insurance, take out directors and officers' liability insurance. As a director, protect yourself. Trading disclosures. The only reason I put this on the slide, actually, I thought this was going to be the laugh. There are actually strict rules about where the registered details, so your company name, your registered number, your registered office, where that information has got to be contained. Dull as it sounds, but so it's got to be on your website, it's got to be on your business letters. And interestingly, you've got to have the full registered name on your checks. And if you don't put the full registered name on your checks, you're personally liable on the check. Yeah, that's pause for riotous laughter. So, operations. Again, just in terms of the startup, that's your building in 5 years' time, by the way. That's Chicago. That's your office overseas. I mentioned recruitment briefly because, again, not my subject, but any employment lawyer will tell you that you've got to be fairly careful about the questions that you ask when you're recruiting. Not to get any potential claims against you for some sort of discrimination under the equality legislation. So, for instance, my employment colleague tells me that I shouldn't ask any questions about marital status or childcare or age or gender or sexual orientation. Not that it's not the sort of thing I normally do in an interview, but those questions are absolutely taboo. Premises, well, you've got to trade from somewhere. And for startups, the moral of the story is avoid commitment if you can. But if you do have to, you can operate from a friend's offices or even operate from home. That's the best option initially. But if you do have to commit to an office, then keep it flexible. Don't sign anything up for more than 5 years. Watch for rent reviews. Don't give a personal guarantee of the rent. And all consistent with what we're saying about capturing or capping your exposure when you've started your business. Funding is going to come from, initially, probably friends and family, if you're lucky. Banks, not so good. I mean, forget what's happened recently. Banks, they're not massive fans of startups in the sense that banks like to have some form of meaningful security if they're going to give you an overdraft facility. And startups don't tend to be synonymous with meaningful security. Equity, well, I've touched on that. Not an easy one for a startup, but there are angel networks out there. And if much depends on the sector you're in and your track record, but there is a lot of money out there, actually. And if your story, we've been talking about stories and so on, and if your story's a good one, there's cash out there. Trading contracts, this is terms and conditions of business. The only thing I've mentioned, again, going back to a theme that emerged yesterday, I think, was collaboration. And again, this concept of sharing and giving information away. The only thing and I am a cynic, unfortunately, but the only thing I'd warn against or just caution against, I guess, is that collaborations are great and they are an alternative to outright mergers and acquisitions, much less risky. But when it comes to sharing intellectual property or know-how, people talk about non-disclosure agreements, NDAs. I don't know if you've come across this. And they think that as long as I get this guy to sign this non-disclosure agreement, I'm safe. Well, you're not. Suing on the back of a non-disclosure agreement, I'm talking about suing, it's 11:05. But actually trying to enforce an NDA is a nightmare. So the bottom line is collaboration is great, but if the information that you're sharing is really vital, just be careful when you release that. So if you can release it in stages, once it's out there, it's out there. It doesn't matter what you get that guy to sign, you're exposed. So forgive me for being cynical, but that's what I'm paid for. So, pearls of wisdom, we're nearly there. What are these? These are what I'd say are things that I hold to be true. I claim no originality here, and I apologize if this sounds a little bit like the sort of Chinese fortune cookie stuff, but these are things I've come across during the course of my career and things which I would impart to you or anybody starting out in business. And as I say, apologies if it sounds slightly patronizing, but price and value, these are not the same thing. And as my father says, that, you know, in business, knowing the price of everything and the value of nothing is not a gift. So just bear that in mind, particularly when you're taking on your lawyers. It's good to listen. People talk about good to listen. It's a lonely place, actually, starting out in business. And if you can take somebody on board who's been there, done it, got the T-shirt, you know, whether or not they're prepared to invest, that's a good thing to do. As I say, it's just take advice from as many people as you possibly can. And you know, don't be proud. Just ask questions. Perspectives. When it comes to negotiations, and again, this is a mellowing of me over the years, my style, and clients used to like this, was pretty confrontational. When negotiating on M&A or commercial agreements, rugby was my game, and there was always a winner and a loser when it came to negotiations as well. And actually, that's a flawed approach. Not that I've got lovey-dovey about this, and I'm still out to get the best deal I can for the client, but when you're negotiating, just try and understand, try and see the other guy's perspective. You know, what is he worried about? Because that actually will get you to where you want to be much quicker. And unfortunately, I say unfortunately, life is about compromise, whatever they say, you know. So we don't go out there saying that we're going to get the best possible deal for you on every transaction, because if we do that, it means somebody else is getting screwed. So there's a balance to strike. Please, sir, I want some more. When you're raising money, and I know that this is, again, a personal view, when it comes to raising money, there's no such thing as too much. You know, one of the big mistakes is when you go out there for the first time, raising some funds is not raising enough. And having to go back to your investors, unless you've got a really good story and a compelling message as to why you're going back, it's a difficult conversation, because, you know, you've put a business plan together and all of a sudden, you know, you've burned through the cash in a matter of months. So, you know, try and avoid those conversations, I'd say, unless it's for a really good reason. Dumb questions. In terms of your relationships or your communications with your advisors, people like me, never, ever be afraid of asking the obvious questions, because they're not. And never, ever assume anything. Don't assume that I've understood anything. You know, I don't. I'm pretty slow on the uptake. And most advisors, you know, the best relationships between clients and lawyers is ones where both are quite comfortable. There's a mutual respect, and the client understands, the lawyer understands what matters to the client. He doesn't go off trying to point score on issues which really don't matter to anybody else. But that relationship only comes about through dialogue, through communication, and, you know, feeling comfortable, as I say, from your perspective, asking the obvious questions, because, you know, more often than not, they're not dumb. I've talked about spreading the equity. I'm a big fan of that, not just because it gives me work, but also because I've talked about aligning interest between employees and shareholders, and I think that's a good thing, as long as you control it, so that, you know, if the employee leaves, you can take the shares back, and if there's an exit, you can make sure that you can guarantee that exit. They're the things I would, once you factor those in, it's basically a good thing. And finally, yeah, well, be nice to your lawyers, because we're important. Finish on a very positive note, and a brazen plug for my firm, Joelson Wilson. The firm acted, or have acted for Innocent from inception, actually. This is a startup in about 1999. I'm not sure. I think one of the guys from Innocent may well be involved in a Skype presentation over the next day or so. But anyway, this was a startup, 3 college friends, 3 graduates who, in about 1999, as I say, were talking about setting up a business and stopped talking about it and actually did it. They started selling these smoothies, and along the way picked up an angel who put some money into the business. And then very recently, I think the ink is still wet, in fact, completed a very successful investment with the Coca-Cola company. And an interesting, not just from the money perspective, but from their perspective, what they've got is an understanding with Coke, an arrangement with Coke where they're going to be allowed to continue that business pretty much as it was. And that's an unusual approach. Actually, it's a grown-up approach from Coke. A lot of large corporates, when they acquire, they subsume the business and they harmonize it and they impose their will on it, forgetting completely what made that business successful in the first place. Coke have had a very different approach and are leaving the Innocent guys to continue doing what they do best. I'm sorry, that was a bit of a ramble. I did set out to talk a little bit more slowly, but it's a lot of ground, and I'm around for a couple of days. You can come into my shop. Not sure where my shop's going to be, but any questions you've got arising from this talk, then please come and see me. And good luck to you. It's wonderful to see so many people considering doing what you're doing, and I wish you all the best in the venture.